Our first speaker is Jack Sharman, a criminal and defense lawyer with Lightfoot Franklin White in Birmingham, Alabama. Jack publishes the White Collar Wire, a Twitter feed dealing with current issues in criminal law of concern to businesses. While you still have your devices in your hand, open up your Twitter account. Search for @WhiteCollarWire, all one word, and follow his tweets. He provides a stream of references to useful information on a daily basis. Jack's story today is how to think like a criminal defense lawyer in order to win your civil case. Welcome, Jack Sharman.
With that introduction, I'll have to remind myself of a cardinal rule: do not drink and post. For everybody except the defendant, criminal cases are more fun than civil cases. There's virtually no discovery. You get to trial quickly. For the defense, there's often no affirmative case to put on. They are intensely personal for both lawyer and client, the client obviously not wishing to go to prison and become the prom date of somebody named Big Jaws. Those observations, though, apply, with the exception of Big Jaws, apply to civil cases. Now, business people tend to ignore criminal issues. They say, we're not criminals. Our lawyers don't wear shiny suits. That's dangerous for several reasons, and we're going to explore this morning what are some of the lessons from criminal trials that we can take into civil cases. The first lesson from criminal trials is urgency. In a criminal case, the government is always ahead, always by months, sometimes by years. In civil lawsuits, by contrast, the case and the lawyers tend to lumber along and we can become reactive. The first thing you should do when you get a plan or case assessment from your outside lawyer is look for the immediacy and the proactivity in the plan. But what are these actual characteristics? There's a bunch of them, but we're going to focus on 3 this morning. First, take the fight to your adversary. Second, make the trial about them, not about us. And third, when we attack, we're going to get to the enemy's rear. Don't wait to counterattack. In a criminal case, if you wait until it's your turn, you will lose the jury. That's because there are too many people who still believe prosecutors and FBI agents. That's because there are too many people who still believe that if the government charges you with the crime, you are almost certainly guilty. Civil defense lawyers will often hunker down in discovery, waiting for that magic moment in mediation, arbitration, or at trial when a polished affirmative case can be put in. In a criminal case, we often don't have an affirmative case to put in at all, and our client may not be able to testify. So what are the takeaway points for a civil case? First, pre-trial, don't wait on discovery. Let's learn, along with the criminal defense bar, how to use efficiently investigators, junior lawyers, and databases. And then at trial, let's put on as much of our case as we can through their case. A lot of important documents can be put in at relatively low risk on cross. Similarly, we can build crosses that are non-destructive, that is, a series of agree questions to either build an element we need or, more importantly, strip out an element that our adversary needs to establish. Those of us of a certain age will remember the Iran-Contra affair and Colonel Oliver North and his lawyer, Brendan Sullivan. Colonel North and Mr. Sullivan turned the hearing before the Special Committee of Congress away from its subject matter, which was the Iran-Contra affair, and into a hearing about the unfairness of the hearing. In a criminal case, we often have nothing to say. We have no witnesses, we have no documents, we certainly have no witnesses or documents that we want to bring into a courtroom. The lesson here is that in the civil case, let's not become so enamored of our own witnesses, our own documents, and our own experts. And in that first case analysis you get from your lawyer, ask yourself this: how are we portraying our adversary as the bad guys? How are we beginning to teach judge and potentially jurors that we're the good guys and they're the bad guys? When Carthaginian General Hannibal defeated Roman forces at the Battle of Cannae on August 2nd, 216 BC, he used a maneuver that has become a staple of Western military thought for the last 2,000 years: attacking your enemy's rear. Why is this so popular? Because if you attack your enemy's rear, you disrupt his lines of communication and supply. You force his rear guard to serve as a vanguard, you open up an attack on his flank, and you give his offense a bitter choice between playing defense or retreating. In criminal cases, the government's case often seems impenetrable from the front, that is, from the indictment and from the media presentation of the case. But its flanks are often soft. What are some examples? Sloppy pleadings, cut and paste briefing, mishandling of electronically stored information, disregard or invasion of the privilege, inability to meet case management orders, failures to make required disclosures. All those things that happen in a business crime case happen in civil cases, and they are ripe for exploitation. All right, so how do we put that plan together when you get it from your outside lawyer? First, a few principles. Investigate now, not later. Analyze now, not later. Ask yourself, do we really need all those witnesses? Do we really need that witness? Use the burden of proof. Use the Constitution. Make it personal and never give up. So let's touch on each of those 7 things very briefly. Don't wait for discovery. Everybody's busy. Everybody's got a budget. Everybody's got something better to do. Everybody's comfortable with discovery. Don't wait on it. It takes too much time. Judges don't like to deal with anything having to do with discovery. And just as in a criminal case, a savvy investigator can appropriately, ethically, and effectively create or not create discoverable documents to be used. Similarly, analyze now, not later. In a criminal case, like I said, the government is always way ahead. You're always playing catch up. Tell your lawyers to have the mentality of playing catch up. In civil cases, and everybody hates this, I understand it. Everybody hates this, especially in 2013. But let's don't be penny wise and pound foolish. Spend the money to analyze fact and law now and get the legal analysis, the document review, and the factual analysis done. Do we need that witness? In criminal law, as in theology, sin is distributed equally. There are none righteous in a criminal courtroom. Every witness comes at a cost to his or her sponsor, and the question is it worth paying the price to get that evidence in? That's because people in a criminal trial who have knowledge generally have that knowledge because they touch at some point the actions that are the factual basis for the offense charged. So that as much as possible in a criminal case, we like to tell our story through their witnesses rather than through ours, because it puts our adversary in an uncomfortable position of either having to accept those pieces that come in through his or her people or to impeach their own witness. The burden of proof. In a criminal case, I'm taking everybody back to first year law school. In a criminal case, what happens? The government has to prove each element of the offense charged by more than beyond a reasonable doubt. Criminal lawyers harp to juries on the burden of proof, sometimes because we ain't got anything but the burden of proof. Civil lawyers don't harp on it enough. The preponderance of the evidence is a heck of a lot of evidence. It's more likely than not. It's 51%. And those concepts can be conveyed quickly and vividly with trial exhibits. I'm from the SEC, not the Securities and Exchange Commission, the real SEC, right? And so I use a football field with a little magnetic football. You start at the goal line. That's where the government starts. They got to get all the way across to 50, right? These concepts, and if anybody wants to email me, I'll just send them to you, the exhibits. But these concepts about burden can be displayed quickly and easily and memorably. Use the Constitution. Civil lawyers never think about the Constitution. Last year, I was in a multi-defendant federal criminal trial. Counsel for co-defendant gets up and pulls out one of those pocket constitutions, right? I prepared myself for supreme cheesiness. Right? I couldn't have been more wrong. It was moving and powerful to hear that solo practitioner tell everybody in the courtroom, judge, jury, lawyers, how important the Constitution was to everyone assembled there. And that is not something that a civil lawyer should be any more afraid of than a criminal defense lawyer. That is, ladies and gentlemen, we're here because of the Constitution. The Constitution protects all of us, due process protects all of us, and the burden of proof protects all of us. I love this quote so much, it's at the top of my webpage. Criminal cases are deeply personal. When it's an individual's liberty is at stake. Reputation, personal or business, is destroyed. Savings and budgets are depleted. Marriage is stressed or destroyed. I think that's what Fitzgerald, in part, was talking about. Look, lots of lawyers can tell a story or your story. The trick, especially in a criminal case, is getting the listener, the judge or the jury, to pull their chair right up to the edge of the cliff and listen to you. Parties in civil cases have to be humanized, and your lawyer ought to take pretrial and trial the same pitch of belief that a good white-collar criminal defense lawyer does. All right, Clausewitz, the military strategist and thinker, gets overquoted a lot, but he is absolutely right about this one. Criminal defense lawyers pursue one great decisive aim. What's that? Basically, their client's liberty. They use force and determination because that is the only thing that works against the immense power of the state. And your civil case and its defense ought to be no different. Thank you.